As that investigation continues, we're taking a look at the larger legal issues surrounding Roe v. Wade.
I spoke with a legal expert earlier to get a better understanding of the legal side of this issue. I'm joined now by Leslie Silva, partner with Tully Rinckey, focusing on family and matrimonial law. Leslie, thanks so much for being with us today. We certainly appreciate your time, and we're going to get right into it here. This takes me back to my first year of law school, and I remember my constitutional law professor saying, maybe he shouldn't have said this out loud, but in evaluating Roe v. Wade, he said, this is a decision I agree with personally, but from a legal standpoint, it's a little bit shaky in my opinion. Why does relying on privacy rights now create this issue for Roe v. Wade and the precedent now more than 50 years later?
Well, it shouldn't is the correct answer, but it does, and that's because privacy rights are broadly, viewed by the court and broadly given to us, and so it can be that at this point the court is looking to no longer follow that path and to not give us privacy rights in that broad way and to perhaps restrict them a bit, which would be unfortunate.
Now, Justice Alito, in this draft, and again, reminding our viewers, this is a draft, Chief Justice Roberts saying that this may not be the final opinion, but in this draft, Justice Alito saying those privacy rights you referred to, this would not extend to things like gay marriage and other things. How does he draw that distinction in this draft?
Well, he draws it in a way to make his point and not necessarily in a way that is realistic. And that is for gay marriage, that case tells us that not only are we using the 14th Amendment for due process and privacy, we're also using it for equal protection. And so we would hope that that case is doubly insulated by those 2 points of view. But we would have thought that about Roe, because Roe references several different amendments that give us that right to privacy. So being able to distinguish this draft from the initial case of Roe is a little tricky.
Now, you brought up equal protection. I want to get to that because it's an important point here. There's different levels of scrutiny the Supreme Court applies to a case based on the aspect of the Constitution that the case forces it to evaluate. In this case, equal protection. What's at play here? What's the level of scrutiny? Why is it so important here?
So if we're not talking about equal protection, then we're talking about a lower level of scrutiny, and that is what happened in Roe, and that is what is happening here. However, if we are using equal protection, we're using that heightened level of scrutiny, meaning that the state would be subject to a higher level of review by the court in order to restrict any rights of privacy.
Now, going back to a point that you brought up earlier, that this really, the court should not be overturning Roe v. Wade, and obviously Roe v. Wade has been upheld on in other cases going, back decades, and then now this court, again in this draft, appears to be making what many believe is a veering off into a right-hand turn. Courts always rely on precedent when they do this. So in this case, they're relying on precedent just in a different direction. How are they doing it here?
They're attempting to take a precedent that allows them to restrict their own authority, which is opposite of what they did in Roe. They took precedent to establish their authority, and they can go both ways, but we do want to see those privacy rights upheld, and so we'll have to wait and see what the final decision says.
So many layers to this potential decision. Leslie Silva, partner with Tully Rinckey, we appreciate your insights here. Very difficult, very complicated. Great to hear from you on this.
Thank you.